Good afternoon, everyone. My name is Mark Towie. I'm a senior counsel in the Food Systems Department of Husch Blackwell. At Husch Blackwell, we're sort of divided into various verticals. And I am an antitrust lawyer, and I work across all the various verticals. But my particular interest is agricultural antitrust law. And I've been doing antitrust law for 35 years, mostly for the government, and I've been at Husch Blackwell for 3 years. Before we begin, and I also also allow my co-presenter, Emily Lyons, to introduce herself, let me give you a few housekeeping items. If you have questions during the webcast, please submit them in the boxes that are at the bottom of your audience console there. We'll try to answer as many questions as we can during the webinar, but if there are questions that we don't get to or require a longer answer, we'll answer after the program via email. You will also find program materials here, which includes this presentation and other things. An article that I wrote that this is in part based on for Antitrust Magazine is also included, and the Treasury Department report on alcoholic beverages and beer, wine, and spirits is also included. So this program is approved for continuing legal education hours, and there's a button at the bottom to report your attendance, and you will receive their certificate of attendance, including course numbers, etc., along with a recording of the webcast after the webcast is over. Also, please complete our survey at the end. It will help us. So let me introduce my colleague, Emily Lyons.
Hi, everyone. I am Emily Lyons, a partner in the Washington, D.C. office. And like Mark, I am part of our food systems business unit here at Husch. My practice primarily focuses on the regulation of food, beverages, and agricultural commodities, which has quite a bit of overlap with Mark's antitrust practice as it relates to competition-related items. So we're very excited that you were all able to join us today. Back to you, Mark.
What we're going to talk about today, we'll go through the items, is a program that'll combine both the subject matter involving production agriculture or agricultural processing, and Emily will talk about beer, wine, and spirits. So our agenda, I'm going to talk more generally about the Biden executive order on competition, and we'll go into rulemakings, policy, enforcement actions on that. Emily, what are you going to talk about on the Treasury report?
Yeah, in the alcohol space, we're kind of going to give an overview of the Department of Treasury and the Tobacco Tax and Trade Bureau's, reaction to Treasury's report regarding competition in the beer, wine, and spirits industry, both what TTB has done and then kind of the impacts on the industry, as well as kind of the reactions from the industry regarding the report and just competition on where it stands in the alcohol beverage market today.
And at the end, we will both try to give some takeaways for you from our respective presentations, and hopefully that will be of value. Before I talk about the Biden executive order on competition from July of 2021, which this presentation really talks about the effect of that executive order on two industries that are not known to be, heavily competition oriented, processing, agriculture, and beer, wine, and spirits. One of the interesting things about the executive orders is it seeks to reach out to non-traditional antitrust agencies like Treasury that oversees alcohol, and USDA that oversees agriculture. My interest in this, and I'll just indulge for a moment, is that I was the chief staff person in the Obama administration on these issues at the Department of Justice. I was the liaison to the U.S. Department of Agriculture. The Obama administration had a similar outreach program to agencies and to the public. So I'm very interested in how this particular outreach effort is going. I was instrumental in putting together the workshops around the country where we interviewed farmers and producers and ranchers about their concerns about competition. And we wrote a report in 2012 on that. So this to me is a new and probably more sophisticated effort than we did in the Obama administration. One interesting thing about it is that the whole of government approach, and I write about this in my article. I think that because the new administration has people and an orientation and this mandate from the executive order to use all the tools in their possession, there may be more of a chance that this sort of effort would result in changes, more competitive markets in agriculture. And that's kind of one of the theses of my article that you have there. There are directives to 72 different directives to at least a dozen government agencies, some outside of the executive branch, and trying to bring in everyone who supervises markets that are considered to be overconcentrated. So, the thesis of the Biden executive order is really interesting. The thesis is that very ill effects on competition, which they detail, result from too much consolidation. And they see agriculture markets as being too consolidated, and over-concentrated is the word that they use. So the executive order, has directives to all these different federal agencies. DOJ and FTC are at the center. The antitrust parts are at the center of this effort. They've been instructed to undertake making tougher merger guidelines, more vigorous merger enforcement, which we've seen in the cases that the DOJ and FTC have brought in the antitrust arena, and focus on things like the labor markets, no poach, wage fixing, and information sharing, which we'll also talk about a little bit. Another part of the executive order is the use of the order that the FTC published, a proposed rule essentially banning the use of non-compete agreements. So that one is still ongoing. There's been a lot of attention paid to that rule and to Chairman Khan as a result of that rule. For this, agriculture is a primary concern of the Biden executive order, and there were a lot of specific matters directed to the Agriculture Department. I'll just briefly mention, and Emily will go into, that there were also directives to Treasury, mostly to write a report. Emily will describe the features of that report. And Treasury produced that report very early on in February of 2022, which contains many recommendations that the states consider revamping their own regulatory schemes, which is where most of alcohol is regulated. So a little bit about the policy. I've said here that this is kind of a change, a paradigm shift in antitrust. The prevailing paradigm has been called the consumer welfare test. the new orientation, has been called various things, but neo. Uh, uh, it's a version of it's sort of Louis Brandeis writ large, and it takes into account a lot more variables of competition than the consumer welfare test. So it's kind of a syllogism that if there are too many mergers, it results in overly concentrated markets and market power, which is concentrated in too few firms. Now, the idea of overconcentration results in markets performing poorly, with stagnant employment markets for employers, alleged to result in unfair, deceptive, or discriminatory practices, undue preferences and market exclusions, supply chain disruption, environmental and waste issues. So, you can see that there are a lot of market problems that are ascribed to overconcentration. So the focus is on addressing overconcentration in agriculture and in other markets. There were many markets mentioned in the Biden EO, but we're only talking about a couple. Part of why, it is, I think, an interesting approach is the people the appointees that the administration brought in to run the program. And the title of this slide and a few slides after this, Personnel as Policy, I think, came from someone in the Reagan administration. The Biden appointees at the White House that started this, and the White House, is all in, as I say here, and we'll get to that. Tim Wu and Brian Deese. Tim Wu is a well-known antitrust economist at Columbia, and he's kind of a proponent of this, as I mentioned, the neo-Brandeisian school, which is, goes well beyond just price and output effects in the consumer welfare. And he wrote a book basically setting out the concerns that come from overconcentration called The Curse of Bigness. Brian Deese was brought in as the director of the National Economic Council, the NEC, and the White House Competition Council, which both sit on, work across government to drive implementation of the Biden executive order. And this is another significant feature. The NEC, for example, brings economists that have expertise in labor markets or antitrust or agriculture, and helps to instill this so-called gospel of competition. The appointees at the various agencies also reflect this same orientation. I think it's fair to say that Lina Khan is probably a neo-Brandeisian and is philosophically aligned with Tim Wu. She has certainly been a critic of antitrust enforcement. And I will say that, she has demonstrated involvement in and interest in agriculture for a long time. She had worked for a Washington organization, a journalistic organization, and produced articles on competition in agriculture even before she went to law school. Jonathan Cantor is the Assistant Attorney General for Antitrust at DOJ. He comes to the job with a lengthy career representing both incumbent technology firms and competitors of those incumbents. He, like Lina Khan, has also been a proponent of more aggressive antitrust enforcement, and they've done it. DOJ and FTC have brought a lot of cases in the last couple of years, and Jonathan Cantor in particular has made news by saying he does not believe that behavioral settlements, commitments to do certain things, are effective, and the most effective way to deal with a competition problem in a merger is to sue. Could also be true in conduct cases. So this is what's going on, in the merger arena. Michael Cadies is a deputy at DOJ, and he's important because he's an expert on the Packers and Stockyards Act and wrote a report for USDA shortly before he became a deputy at Antitrust on how to reinvigorate the Packers and Stockyards Act. So I need to say, personnel is policy, but sometimes the people leave. So it'll be interesting to see what happens. Tim Wu has gone back to Columbia, and then Brian Deese has been replaced by Lael Brainerd. There isn't a replacement for Tim Wu yet, but the White House is expected to replace somebody, and Tim Wu was recently said that in an interview that President Biden is into this whole area. He said Biden is into it. So they expect to have the new competition advisor appointed shortly. The last person I'll mention, and then I'll turn it over to Emily to talk about the Treasury personnel, is a guy named Andy Green, this is a new position from what I'm aware of. He's a senior advisor to Secretary Vilsack on competition matters. And I think some of his handwriting is on work that we'll talk about here. I would be remiss if I didn't also mention Secretary Vilsack, who's a veteran of the prior administration, Democratic administration. It kind of has the handbook, on ag reform from the Obama administration. So I think it's fair to say he's very much with the program as well. Emily, what about Treasury?
On the Treasury side, there are less political appointees than some of the other groups. The individuals I have listed here on the TTB end, we'll start there, are all career individuals who have been either at TTB or part of the federal government for a number of years. Carrie May, for example, is an attorney who's been with TTB since about 2013, and actually prior to that came from the Department of Justice. So she and her field operations team, which you can see is, where the trade practice and trade investigations piece anti-competitive behavior is investigated and enforced. They do have an eye for these types of things, even prior to what the Department of Treasury issued in their report. And then going back to Ben Harris, he is the Assistant Secretary for Economic Policy, so is a political appointee. He has a very similar Brandeis, neo-Brandeis type of background, as Mark mentioned, for many of the other appointees, and comes from a strong business background prior to coming to the federal government. I will say, though, he and the Economic Policy group at Treasury have been focused on some other issues, not necessarily competition and alcohol beverage, and have really relied on or planning on relying on TTB to truly be the ones who are the point of the spear as it relates to addressing competition in the alcohol beverage market. So back to you, Mark.
Thanks, Emily. So then my thesis again is the orientation, the mandate from the Biden EO and the people that have been brought in, and their particular neo-Brandeisian orientation, and the determination to use all of the tools that are available for enforcement activities, such as rules, guidelines, bringing particular enforcement actions and legislation. So that's what I'm going to talk about now. A preference that the executive order seems to state is for statutory rulemaking, which is interesting. the FTC and DOJ are not known for making rules. But I think the use of and emphasis on notice and comment rulemaking, rather than bringing cases and changing the law case by case, indicates that this administration is in a hurry. They want a lot of big changes, and they want them fast. But I think one thing that everyone needs to be aware of is that it can't just be a standard that exists for the current administration. If these changes are going to be enduring, there has to be what Bill Kovacic, who is a former chair of the FTC and a professor at GW Law, called a stability of perspective. In other words, there has to be acceptance of these standards and guidelines. So we'll see if that's the case. Some of these rulemakings, and I'm thinking in particular about the non-compete rulemaking that was just issued, could be vulnerable to the major questions doctrine, which we've heard about in terms of lawsuits over, for example, EPA rules that affect the entire economy. So, there are a lot of issues in terms of the ability to take these rulemakings and bring them and make them law. One thing I also thought was interesting is that the White House Competition Council and the National Economic Council will be involved in coordinating legislative efforts. And we'll talk about legislation in a little bit as well. I should note, we've indicated the big projects that DOJ and FTC have in the competition arena. The one little note that I would make for this group is it is certainly arguable that the Federal Trade Commission doesn't have statutory authority to impose the non-compete ban on entities that might be subject to the Packers and Stockyards Act, the PSA. So that's something worth looking into. Those entities would then be subject to whatever sort of non-compete rule that would come under the PSA or the USDA might promulgate. But the FTC has certain gaps in its statutory authority. That's another way in which these things might get challenged. So I said at the beginning, there were lots of directives to various agencies, the ones to USDA. The general demand was, just address unfair treatment and improve conditions of competition. And one way in which the Biden executive order, the executive administration wants that to happen is to strengthen Packers and Stockyards Act marketplace fairness rules, including rules dealing with the tournament system in poultry, which we won't talk in depth about, but that was something that the Obama administration heard about 15 years ago and has been a long-standing complaint in agriculture. There are also a couple of long-awaited rulemakings on product of USA or made in the USA and organic that were directives and that have actually come out, as we'll see. Another interesting part of this is the administration determined it could take some money from the Inflation Reduction Act and some other measures and use that money to actually provide grants for direct investment in certain areas where it is felt that competition is missing or that access to these resources is limited or more limited, and it might be affecting prices and output of these markets. So there's an idea to do direct investment in meat and poultry processing and in domestic fertilizer. which is, tends to be controlled by Russia and some other countries, resulting in some real hardships for U.S. farmers in terms of fertilizer costs, have been true, recently in particular. Another directive is to develop a portal, a complaint portal, which is farmerfairness.gov. And that portal is to be monitored by both USDA and DOJ. And the work is to determine whether these complaints are actionable and who, DOJ or USDA, might be best suited to pursue the complaints that come in through farmerfairness.gov. I have no idea of how effective it's been, but the administration has been very much touting the complaints the anonymous complaints that have come in. There were also directives to increase transparency for producers, and that includes a library of production and supply contracts that are used by processors, and certain new reports that report on formula marketing, which is a major way in which packers buy livestock. Also directed to publish a report on seeds, which just came out. So we will talk about that too. How did USDA respond? Well, they responded very vigorously, as one might expect. I'm not going to try to, cover every element of USDA's response, but among the things that were said was that, USDA has promised to review all of its own programs to make sure that competition is getting an appropriate emphasis in those programs, and admitted that this hasn't always been the case at USDA, but that USDA has kind of promoted what I think they called hyper efficiency, or what other people have called a cheap food policy. And so I think there's some feeling to go back and look at all those programs and look at them in terms of effect on competition. Major rules that have already come out. This one called inclusive competition and market integrity. We'll talk about. The tournament system rules we'll mention, but not talk in depth about. Those are two major rules. In terms of the processing grants that I mentioned, USDA has pursued that program, and they have about $164 million in grants out in the states that are mentioned on that. Fertilizer, I'll go to that and then come back to seeds. That program is in its first round of grants, and there are 8 businesses in 6 different states that are being supported to try to develop domestic fertilizer resources. The seeds report came out. It's a very difficult issue that we'll talk about. It was long awaited, and it just came out. The formula trade reporting that USDA was directed to do has also been implemented through the AMS News, as well as these 2 big rules on product of USA and organic. And I should mention, since I worked for many years for state AG, that state AGs have a big role in agricultural enforcement in this country, and in antitrust enforcement as well. So there's an enforcement grant program that USDA is administering with the state attorneys general. In terms of the rules that have come out, there are these 2 big ones: the poultry contracting rule, as well as an advance notice of proposed rulemaking on the tournament system. My comment on that is that that advanced notice of proposed rulemaking looks like the USDA would like to curtail the use of the tournament system, and is trying to develop a record to be able to do that. The other big one is this inclusive competition rule that deals with unfair discrimination, deception, and retaliation. So those are the rules we'll focus on here. Let me talk first about the inclusive competition rule. I've tried to summarize in that first bullet what the rule is trying to do, the types of conduct it is trying to prohibit. Undue prejudices against market vulnerable individuals and co-ops, and I don't know if this is my innovation or if others are calling them that, but I'm calling them MVICs, market vulnerable individuals or co-ops. And it's designed to eliminate undue prejudices against MVICs, unjust discrimination resulting from retaliatory or adverse actions that imperil the assertion of rights by MVICs, and then deceptive practices in conduct formation, performance, termination, and contract refusal. And the deceptive practices provisions are not limited to MVICs. So it protects, this is the sort of the statutory basis in the Packers and Stockyards Act. It protects covered producers in all aspects of contract formation, non-renewal, cancellation. There's a long discussion in this rulemaking about production contracts versus marketing contracts, and I would commend that to you because there are implications. If something is called a production contract, there are more record-keeping requirements and other requirements. The covered producers clearly include the MVICs, and then market vulnerable individuals. The definition used in the rulemaking is groups suffering historical exclusion on the basis of race, gender, religion, or other bases. And certainly USDA has a history that they're not proud of having excluded certain racial minorities and others from participating in federal agricultural programs. So I think that's part of this. I think they also feel like these bases for exclusion are hurting competition in agriculture. So to me, this approach wasn't what I expected. We knew there was another rule coming out about undue prejudices and preferences. I didn't expect it would go down this particular path. I thought it would be more about economic discrimination or price discrimination, but it took the rule in a kind of a different direction. And part of that is that the requirements on USDA are such that in order to make these rules, this particular inclusive competition and market integrity rule work in the circumstances in which it needs to work, in other words, individual instances in which there has been some sort of anti-competitive action taken against a producer or an MVIC, in order for that enforcement regime under the Packers and Stockyards Act to work, the USDA has to turn the federal circuits around on their interpretation of the Packers and Stockyards Act. The Packers and Stockyards Act was enacted in 1921, and I think by all accounts it was intended to address the conduct of packers, meat packers, that didn't come squarely under the Sherman Act. And the Packers and Stockyards Act, has been interpreted, despite this history, as an antitrust act. And I think that is because judges are worried about federalizing contract disputes in agriculture. And so, they sort of engrafted certain requirements on the Packers and Stockyards Act to have to show market-wide impact. And this is hard to do, and the cases that are Federal Circuit cases that are out there on the Packers and Stockyards Act are not showing or finding market-wide impact when there's one individual affected or something, of that nature. So that it's not market-wide impact. I think that although this is an unusual concept about market vulnerable individuals and co-ops, I think it may be, an attempt to sort of use group mindedness, to say if this particular group is affected by conduct, that's more than one individual. That's market-wide conduct. I think there may be an attempt to do that. Also, in the rule commentary, there's a suggestion that violations would be per se. In other words, there would not have to be a proof of anti-competitive market effects, which would be another way to get around the curtailing of the effectiveness of the Packers and Stockyards Act as is perceived. One observation that I would have is throughout all of this, the amendments to the PSA and to these undue preference provisions, it's not clear to me anymore how economic or business justifications would be factored in. I will say that, the prior guidance, which is more along the lines of economic discrimination, are still there. They're not repealed, and there's some guidance about what kinds of conduct may or may not qualify as undue prejudice or preference. I said the SEEDS report came out, and it came out on, I think, March the 3rd. It's a very difficult area of the law. It involves the intersection between antitrust law, which generally promotes free markets and free market competition, and the patent system, which is a government-granted monopoly, so to speak. So this has been a problem for many years. It's something we heard going back to the 2010 workshops that I was involved in. The report kind of takes these issues on and is, I think, creditable in that regard. It draws some conclusions, which are stated on this slide. The most important one to me is the idea that that prior art, which may result there. It's difficult to properly or accurately search prior art in plant patents, and so some of these patents, as has been complained about, may include more asserted rights than should be based on prior art. Also, there are licenses that seem to be overriding various research exemptions. Interestingly, there's a chart in this, or a couple of places in this report that I've never seen before. It was work that was done by the U.S. Patent and Trademark Office in combination with USDA, where it sort of sets out by crop who owns the patent rights and the PVP rights by crop. And there is certainly in these in these diagrams a suggestion of a high degree of concentration in certain crops, such as 76% of rights in soy owned by 2 companies, 85% of rights in corn owned by those same 2 companies. So a question that I have is, what is USDA or FTC going to do about that? It remains to be seen. In terms of recent enforcement, as I mentioned before, there have been a lot of cases brought. The USDA and DOJ and the Federal Trade Commission entered into an enhanced memorandum of understanding, and that cooperation is driving a lot of work in the agriculture area. And some of that work is being done by DOJ and FTC in consultation with ag. So, there are many merger challenges that have been brought. Some of those merger challenges have resulted in people abandoning transactions. Some have gone to court. DOJ and FTC have won a few. They've lost several. Some of those losses have been in the agriculture area. There was a merger involving sugar companies that DOJ was unsuccessful in getting a court to impose an injunction against. And then there's the poultry price fixing cases where DOJ was seeking criminal convictions against executives in some large poultry companies, and actually tried the case 3 different times and did not get a conviction. So this is aggressive. I mentioned Coke and Pepsi, completely off topic here, but FTC recently indicated that they're looking at soft drink deals with large retailers under the Robinson-Patman Act. That's another one of these tools that I think the Biden EO suggests should be used in dealing with competition problems. So the idea that the FTC is looking at whether there are preferential deals being given to the largest wholesalers and retailers as opposed to mom and pops, could have real implications in agriculture. The Robinson-Patman Act, not too differently from other acts at the time, such as the Packers and Stockyards Act, was really intended to protect mom and pop retailers. So a couple of other areas where there's been activity, working with the FTC, I think, USDA cooperated, and there was a major lawsuit, including several state attorneys general, against Syngenta and Corteva over loyalty programs for these insecticides and other crop protection chemicals. And the allegation is that is suppressing competition for generics, which is something that we certainly see the FTC arguing and proving in pharmaceutical cases. So a question that I have is whether they will take the same approach here. And perhaps they will take some of the similar approaches in dealing with patent and plant variety rights in seeds. Remains to be seen. In terms of processing, the big item there was an interesting lawsuit and consent decree involving Cargill and 2 other poultry processors. And what's interesting about it is that it was the settlement had 2 aspects. One was a Sherman Act civil violation for information sharing. The other was a Packers and Stockyards Act violation. So who knew you could sue directly under the Packers and Stockyards Act? But I think Michael Kadish at DOJ certainly understood that that was possible. So they brought this action and got relief that actually exceeds what's required under the tournament system rule. Now, the other thing that's going on is that these labor-related, wage exchanges that were part of this case is something everybody should be looking at, and we'll cover that in takeaways. Briefly mention legislation here. There are various pieces of legislation that were filed last congressional session. Those had to be refiled here and in this new session. One or two, the congressional part of increasing processing resources was refiled. It is said to have some bipartisan support, but there is actually a fair amount of opposition that's starting to show up in Congress. Yeah, and all of this is to say that these great initiatives and these aggressive changes that are being pursued are likely to hit a lot of pushback. There are legal challenges possible. There are, the NPPC just filed its comments on the inclusive competition rule, and it sounds the same themes, that we've been talking about: the major questions doctrine, the vagueness that could lead to costly litigation, the floodgates argument, the idea that current law requires proof of market impact, which we've talked about, and the idea of federalizing state contract law. So there are lots of ways in which these initiatives can be disrupted by Congress acting, or the industry acting through Congress, Farm Bill deliberations, the Congressional Review Act, and we're starting to see some of that. Now I'll turn it back to Emily.
Well, Mark, before we do that, we do have one question in the chat that has asked, how often, if ever, have you seen USDA's enforcement of PACA, the Perishable Agricultural Commodities Act, or the Packers and Stockyards Act, to impose a constructive trust on land for non-payment by a downstream market participant?
Oh, that's one that I'll have to come back on. I don't have that information just off the tip of my head.
And I can speak on PACA. I don't think I've ever actually seen that done, partially because they do require a trust account basically to be established by downstream market participants in order to either be a broker or somebody who is purchasing perishable ag commodities. So I don't necessarily expect that it would be common under the Packers and Stockyards Act either. So moving over to alcohol in beer, wine, and spirits, very similar in the meat sector, the executive order issued very specific directives both to the Department of Treasury, which is the parent agent, or the parent department really over TTB that is a part of it, as well as some specifics for TTB to consider. And many of these recommendations you'll see kind of follow theme, like Mark has in the meat space. They follow theme down in some of the actions that have been taken. And really, the executive order directed the Treasury to, create this review and report of the current regulations and competitive environment in the alcohol beverage system. And they're truly meant to focus on how to improve market access for smaller, independent, and newer operations, because we do have some very large companies in each of the different sectors of the alcohol industry. And we have new market entrants, and sometimes they have issues, breaking into the market. But specifically, the Department of Treasury, along with the Attorney General's Office and FTC, were asked to really focus on the unfair trade practices that have been complained about by smaller and independent operators, as well as the consolidation that's been going on in the industry, both at the production, distribution, and retail level, and the impact it's just having on consumer prices as well as the market as a whole. And then looking at some other areas that are maybe not they're trade practice regulations, but they're really more on the operating side, how you're producing products and marketing them to people, such as our standard of fill, which are bottle sizes, as well as the permitting requirements by TT, and then some of the labeling things that don't have a tie back to public health, providing consumers with information, or the primary purpose of regulation of alcohol, which is to tax alcohol beverages. And then on TTB's side, they were asked to, take a look, since they're the ones who enforce and implement the trade practice regulations, have them take a look at that and update them, since they have not been updated in a number of years. Also consider revising some of the regulations that they have that may inhibit competition, and then also look at ways that they can reduce market barriers to market access, such as some of the permitting requirements for these smaller and independent producers of product. And before we dig into exactly what TTB has done and is looking at, for those who might not be as familiar with the alcohol beverage system, it's very horizontally regulated is the best way to say. There is no vertical integration in alcohol. You cannot be a supplier, wholesaler, and retailer all in the same. And this came out of the 21st Amendment and the Federal Alcohol Administration Act, where we have what's known as the three-tier system. Your top tier are your suppliers, those who are making the product or owning a brand that the product is sold under. And for the most part, they can only sell to licensed wholesale distributors. Now, there are some small exceptions, such as, the opening up that we've had in direct to consumer sales by producers or craft breweries or brew pubs. But those are all regulated more at the state level. So after the product is sold to a wholesale distributor, they are then the only entities that are allowed to then go and sell to licensed retailers. And then retailers, whether it's package sales or consuming a beverage on premise at a bar or a restaurant, are the ones who are only able to sell directly to consumers, minus those, new exceptions that we've had that are kind of breaking up the three-tier system in some locations. So just with that in mind, you can have horizontal acquisitions, but a supplier is never going to be able to own a distributor or own a retail location. And they really try and keep it separate to make sure that there's not abuse in the alcohol system. So in light of that, Treasury wrote this really long, detailed report regarding, concentration in the alcohol beverage space. They noted that there's been quite a bit in the beer production area. We do have two large, beer companies in the United States and globally, as well as, they're looking at very specifically the geographic expansion that some of the large distribution companies have had that has made it more difficult for craft brewers, especially, to enter a market. They're also, following a request for information to help make this report, Treasury noted a large number of complaints of exclusionary behaviors, which we'll touch on a little bit later. Also, there really was a look at and some, criticism of disproportionate burdens on small and medium-sized producers, again, with that public health piece not being met or actually preventing competitive behavior. The Treasury Department listed some examples, but not necessarily provided specific direction. And this whole report was, really based on these hundreds of comments that they received. And then also they looked at some areas where, consumer transparency, such as some of the labeling requirements or labeling options that we'll talk about a little bit later, haven't been implemented. And then also, they talked a little bit about some of, vertical integration prohibitions, but there are some questions about whether or not the three-tiered system is dated in alcohol, and it's something that TTB as well need to look at kind of differentiating and changing from. And then also, if you work in the alcohol space, you know that beer, wine, and spirits are all taxed differently. And then there's also a difference based on domestic and international. And, Treasury instructed TTB to kind of look at those tax rates to see if there may be some improvements that could be made there that reduce barriers to entering into the market. And then also they noted, this change in the direct to consumer market that I mentioned, where suppliers are able to sell directly to consumers, where they see that that's a great opportunity for them to, have more access to consumers, a little bit more control over their product, and have an easier route to market. However, they did note that, there are some concerns where when you're doing direct to consumer sales, especially if you're a producer, let's say in Iowa, of a distilled spirit, and you want to sell it to someone in Illinois, and they want it shipped to their home, that could potentially increase the access to underage individuals. But there are state laws that do address whether or not, under the conditions where those things can happen. Now, some of the key we've kind of touched on, but really, they have asked TTB, FTC, and DOJ to really focus in on some of these activities. So it's especially category management. And this was mentioned in a number of the complaints that, in the comments that Treasury received. And this is where large producers and distributors act as kind of category captains. And they complained that this erodes the independence of a retailer, either through an inducement or by controlling the software that is used to, help facilitate the sale and distribution of alcohol beverages. And, the recommendation was that, these need to be looked at, and whether or not category management is something that needs to be specifically prohibited in the alcohol space. And, it's kind of to be determined on whether or not that'll happen. The Treasury report was also highly critical of what are known as tying arrangements. And this is when distributors require retailers to buy an undesired brand as a condition of buying its desired brand, or a distillery requires a distributor to buy its non-premium brands as a condition to purchase its highly sought brands. So you're kind of tying these two products together. And it's an area that could be a focus of, now that we're seeing more non-alcoholic brands entering into the alcohol beverage space. I don't think we can go a day without hearing some new ready-to-drink beverage, whether it's a cocktail or a malt beverage that kind of tastes like a cocktail, and really using their ability to leverage their relationships with retail partners in a space that is not regulated in this strict three-tier structure, to be able to have their brands receive more prominent space in the marketplace. And then also exclusive contracts, which are where, a dominant distributor in the market could use an exclusive contract with a supplier to not allow smaller new distributors in the market space to be able to sell that product. So then they could build their own larger distribution system. Additionally, there was a large call to action specifically for FTC and DOJ to review alcohol beverage mergers and acquisitions a little bit more critically. Again, looking both at these horizontal overlaps when a large distilled spirit company may be purchasing a smaller new craft spirit, or where distributors, are buying smaller, more regional ones to, have a new presence in a state. They also were recommended that some of the more horizontal mergers, even though they're fairly prohibited, but seeing how those horizontal mergers may actually have an impact in a horizontal way within the marketplace. So if you have only one large producer, let's say in the distilled spirit space, that could actually cause impacts on the distribution tier. So they're asking them to look at both horizontal as well as vertical to make sure that there aren't impacts across the tier system. And then also, especially in the distribution space, when multi-state distributors are acquiring new distributions in different geographies, seeing how that would potentially impact negatively or positively competition in this space. And it happens, it gets a little complicated sometimes, especially in franchise states. So there are certain states that don't allow you as a producer to easily fire your distributor in a state. And, does this type of acquisition in a franchise state continue to inhibit competition in this space? So those are the things that Treasury has asked TTB to look at. Additionally, they recommended TTB engage in these transparency areas that I've mentioned. And then there was a big call to action because alcohol is so duly regulated by both the federal and the state governments. For states to really consider evaluating the tier system, study what some of the states have done where they've loosened up the 3 tiers, and then determine if the state franchise laws that exist are actually beneficial anymore, especially with these larger distribution companies that we have. So what TTB has done so far in reaction to this is focus on the trade practice pieces, because that's what we're hearing the most complaints about. Additionally, we just recently revised the alcohol labeling regulations and requirements to where I doubt those will be revisited anytime, super soon. But it is something that TTB is considering, but they're focused on the trade practice piece. And it's the first time in 20 years we've looked at these tied house arrangements, which is, what keeps you from within your tier. As well as, exclusive outlets, whether or not, you say, I make this product, but you can only sell it to these 3 retailers. That's something that's prohibited. Same with commercial bribery and consignment sales. That focus is really in on the payment terms, and it's something TTB's been hearing a lot about over the last several years. So they opened up a request for comment. So this is kind of like the preliminary piece of a rulemaking. And, they're accepting comments until June on a wide variety of topics, specifically looking at category management, how the digital marketplace works, now since 20 years ago, we didn't necessarily have as much of that. And they're really looking at each of the different areas. Are there things where third parties are actually producing and furnishing inducements for retailers that, would be prohibited by me as a supplier or a wholesaler being able to do that? Additionally, there's some interest in, if you've ever held an alcohol beverage license, not only you as a company and your offices are vetted, so also especially in the retail space, your property owners are going to be vetted, and they're looking at whether or not, there could be some loosening up of the restrictions regarding, potentially a supplier or distributor having to own that property. An area that is a huge piece of focus is the slotting fee piece. It is prohibited to do slotting fees in the alcohol beverage space at this point in time, but with our new non-traditional alcohol beverage companies entering into the marketplace, slotting fees are very commonly used in food, and TTB is wondering maybe that's something that they should loosen up in the regulations, or is it something that's being done in the marketplace and maybe not being called a slotting fee to get that product, that prime market, space in the marketplace? A number of other areas, such as looking at third-party contracts. They're also looking quite a bit at contract manufacturing agreements where a retailer may have an exclusive brand, and, what other retailers could be looking at it. And an area that I know is of particular interest, especially to suppliers, are the restrictions regarding sponsoring ballparks and concert venues. So these are all things, TTB's kind of thrown the watershed at us in the alcohol industry and is asking for our feedback on how they think the areas should be improved. Now, some of the pushback that we're hearing and some of the obstacles that we face is this dual regulation at the state and federal level. While some states have very similar trade practice restrictions as TTB, many are much more restrictive and specific. You can always be more restrictive than the federal standard, but you can't be less. And some of these restrictions have been upheld when challenged in court, even very recently, such as these out-of-state retailers being able to sell to in-state consumers in a different state. Or, one state famously prohibits publicly traded companies from holding retail packaged spirits licenses. So, if you're a publicly traded large retailer, you can't actually sell liquor in the state. You may be able to sell beer and wine, but not other things. And then truly, because states are the primary regulatory authority that have the most sight onto a lot of these things, is they'd need to take some action in order to adjust the regulations or provide the alcohol control agencies the ability to modernize their regulations in some way. But there's been a lot of criticism of the Treasury report, in the alcohol industry. Many of them don't think it is correct or represents the current state of play. Many believe that competition is really strong in alcohol. Yes, there are some very large players that do, many strategic acquisitions, but we've seen so many new entrants into the supplier tier, they question whether or not there isn't true competition. And then additionally, there is, some wholesale organizations echoed that concern regarding direct to consumer sales. But, obviously suppliers welcome the opportunity to be able to more directly engage with consumers as it relates to them. And then, the supplier tier has again welcomed those state franchise, law changes, as well as really hoping that both states and TTB will truly be enforcing the discriminatory practice pieces, even of the existing trade regulations, just to make sure that, everybody is having a fair, even playing field. So it's a little similar to the meat industry, but, a lot different, where your specific activities in the marketplace compared to contracting are being regulated. Granted, the contracting pieces are also being regulated, but not at the same level. So Mark, back over to you for some of your takeaways.
Great. And we've talked about some of these along the way, but, and I'm sorry, we've gone over just a little bit, but a few that come to mind, as you would have gathered, there will likely be more enforcement cases and potentially more direct enforcement of the PSA by DOJ. There will be more litigated merger cases, conduct cases, and PSA cases. And don't expect the federal enforcers to pull back from this initiative, even if they lose. I think they're determined. The PSA rules and other rules, as we've talked about, may face a real gauntlet of challenges. I guess I would say that because what it involves is documenting and explaining any actions in contract formation. I think that's good, best practices anyway, but I would suggest that in the interim, you sort of internally treat other contracting parties as if they are MVICs, market vulnerable individuals and co-ops. And we mentioned this emphasis on information exchange and benchmarking, particularly wage related, that came out of that Cargill enforcement action. That's resulting in a whole series of private cases against companies who are perceived to exchange too much information about worker wages. And there have been a number of private class actions brought in that area. And the government is continuing to pursue information exchange. So Emily, what about alcohol?
Yeah, I think the biggest thing is we should expect some changes to the trade practice regulations within the next 5 years as TTB looks to modernize them to reflect the current market. I think, because there's been so much criticism and focus on slotting fees, not just by, the Department of Treasury, in their report, but the Federal Trade Commission actually started asking about slotting fees in its own review of the retail marketplace that I believe started early last year, which potentially could be the genesis of this Coca-Cola Pepsi inquiry that they're working on right now. As we see, these are two of the large, traditional beverage, soda companies entering into the alcohol space, who are commonly used to using, their own distribution systems and their own owned distribution companies, seeing how they are, going to be able to be licensed and actually be able to make money in the alcohol space, since you're required to have state licensure in order to get any of that money. So there's going to be some scrutiny on what those businesses do, and it's going to be a really big shakeup. And we've seen, really this focus on the distribution tier more so than the supplier or the retail tier. But don't expect wide scale changes. Even if TTB makes changes to the trade practice regulations, state level is really where a lot of this action is. They have a lot more direct authority over the alcohol that moves and enters into their state, to where, they may not make same changes to kind of loosen up some of this, due to the desire to keep, some really strict control around alcohol. So with that, Mark, I think, I don't see any other questions in the chat box right now. If anybody who's still attending happens to have any questions, our contact information is available. And, we welcome any reach outs or anything like that if there's any follow-up questions that you have.
And thank you all for joining us today. We hope this was valuable to you. Be sure to pursue the continuing education credits, and you will get a mailing from us. And if you do have other questions, we're happy to look at them, and we'll get back to you after this, as well as if you don't mind doing the survey, it always helps. Thanks a lot.